Mr. Chairman, dear guests, there are 200 participants in today's event. Among them are foreign diplomats from 55 countries and more than 40 heads of diplomatic missions of foreign states and heads of international organizations, 35 ambassadors of Kazakhstan abroad. We hold the event with Sir Chakrabarti, external advisor of presidents of Kazakhstan and Uzbekistan, Deputy Chairman of the Supreme Council for Reforms, ex-President of European Bank for Reconstruction and Development. A few words about the members of International Council. Mr. Masters represents the United States, Baker McKenzie law firm. Mr. Pudelka, judge from Berlin, one of the authors of the administration justice of our country. Mr. Beer from Oxford University, former president of International Association for Court Administration. Ms. Kachalova, scientist from Russian Federation. Mr. Hwa-Jong Lee, lawyer from the Republic of Korea. Mr. Campbell Holt, registrar and chief executive of the AFC Court. And Mr. Slade, scientist from Nazarbayev University. Academic Mr. Suleimanov and scientist lawyers Mr. Yolubayev and Ms. Kenjibayeva from Kazakhstan. They're well-known experts in the legal field who contribute significantly on the development of justice. The judges of Supreme Court and the staff of the judicial administration are present in the hall. The chairmen of regional courts are participating online. Dear guests, you can review all materials using the QR code. Ladies and gentlemen, we are about to start our briefing.
Наш брифинг. Прошу продемонстрировать наш видеоролик. За годы независимости в Казахстане создан прочный
Established in Kazakhstan. This doctrine fully complies with international principles and best practices. The plan of the nation launched a new stage in the development of Kazakhstani justice. The three-tiered court system has replaced the five-tiered one. The requirements for the selection of new judges and the quality of judicial acts have become more rigorous. State-of-the-art information technologies and court services are implemented. Investment proceedings have been established. Launched in 2018, the 7 Pillars of Justice program is rapidly
стремительно меняет облик суда.
Thinking paradigm of judicial decision makers. This reform is not top-down, but bottom-up. Based on project management principles, judges, independent foreign and domestic experts, as well as active legal community representatives participated in the reform. As part of this update, the following have been introduced. New standards for the professional judicial evaluation, user-friendly court services and court administration, new formats of judicial acts, digitalization of justice, communication of courts with society, development of mediation before the court and in the court. The judge is the central figure in the court proceedings. To implement the objectives set by the Elbasi and the head of state at the initiative of the Supreme Court, 30 draft legislations have been developed, 21 of which have been adopted and are already in force. The adopted Administrative Procedure Code introduces new rules for the consideration of disputes between citizens and businesses with government agencies. There is the principle of presumption of guilt of the government agency. From now on, the legality and validity of its decision shall be justified by the government agency. It is enough for a person and companies to file a disagreement statement with the administrative body's decision. It makes the protection of citizen rights easier. The judge has no link to the scope of the claim and controls the execution of the decision. A fine is the coercive measure to ensure execution. A professional judiciary is the key to enhance public trust in courts. Judges must be a beacon of honesty, impartiality, fairness, and high morals. This is the only guarantee of public trust and confidence in justice. To strengthen the judges' independence, the issues of their career promotion and accountability have been transferred from the Supreme Court to the High Judicial Council. It is an autonomous structure and outside of the judicial system. All decisions on the selection, appointment, punishment, and dismissal of judges are taken collectively by the High Judicial Council. Its members are the Chairman of the Senate and Majalis committees, the Prosecutor General, the Minister of Justice, the head of the Anti-Corruption Agency, lawyers and judges elected from all judicial instances. The selection of new judges has become rigorous. Candidates have to take a psychological examination and legal knowledge test, solve case studies, write essays, and participate in individual interviews. A new institution, the Justice Quality Commission, has started its work. A new professional evaluation methodology of judges has been adopted, evaluated by international experts as a unique and objective instrument. There is no place for corruption and abuse in the judicial system. In the last 3 years, 54 judges were dismissed for various violations. 15 judges were convicted, which is a few times more than in the previous 3 years. Citizens trust in the court through improving the quality of justice. Since 2018, the courts were relieved from unnecessary bureaucracy. There are more claims for which no litigation is required. The benefits of mediation were explained to the population. In criminal cases, there are now more acquittals. For serious and especially serious crimes, it increased by 3.5 times. Investigative bodies and prosecutors dismiss more cases that have no prospects in courts. Many administrative cases have been transferred from courts to the government agency's jurisdiction. Since 2019, night courts have started their work. They contribute to the expeditious handling of administrative cases at a convenient time for citizens outside working hours. Courts during COVID-19. During the pandemic, the courts quickly switched to an online format and did not stop proceedings even for a single day. In the first days of quarantine, the number of servers was increased from 67 to 152. Today, courts accept up to 95% of documents electronically. The number of daily remote court sessions has increased by 30 times, from 150 before the start of the state of emergency to 4.5 thousand. 95% of all processes take place online. It is possible to participate in the court even being abroad. Kazakhstani judicial system in global ratings. Kazakhstani justice system improved its position in global ratings. According to the WJP Rule of Law Index, the Civil Justice Indicator, Kazakhstan improved by 10 positions, from 50th in 2017 to 40th in 2020. On criminal justice, it increased by 12 positions, from 70th in 2017 to 58th in 2020. According to the Doing Business Rating, Enforcing Contracts Index among 190 countries globally, we hold an honorable 4th place. There is still plenty to be done, and we are full of strength and determination to continue judicial reform in the interests of justice and the rule of law. We strive to ensure that citizens, businesses, investors, and partners of Kazakhstan have confidence in our courts and judges.
Good afternoon, dear ladies and gentlemen. Today we are attending a unique event. Why is it so unique? It is unique because it is being held within the framework of the meeting of the International Council under the Supreme Court, and we are holding such a briefing for the first time for the representatives of the diplomatic corps and international organizations. We will talk about the changes and about the situation in our courts in general. We admit the fact that we have a lot of problems, and today we will indicate at 7 painful areas or spots. Another question is, how do we overcome them? This is what we are going to talk about today. Nazgul Irgaleva is going to provide a presentation. She is an independent human rights expert, and she has a good background. She is among those people who boldly criticizes courts. She studied and worked in the USA and in Europe for 10 years. She has master's degree in human rights and public policy. She implemented a number of projects of international organizations, including those ones of the European Union, and she successfully defended 3 alternative reports on Kazakhstan in the UN. She won a number of individual complaints to the UN Committee Against Torture against Kazakhstan and Kyrgyzstan, and given her experience in the field of protection of human rights, we asked her to join our work on reforms today. Nazgul, the floor is yours.
Excellencies, ladies and gentlemen, It gives me a great honor to address you today on the important theme of the judicial reform in Kazakhstan. I joined the group of the Supreme Court reformers in 2018, and I was able to discuss the strategic and operational aspects of these reform initiatives. Today, on behalf of this group, I would like to briefly present most important developments. More details are available for you in the additional materials. We started this process with the identification of problems: lack of independence and impartiality, corruption, and professionalism of judges have long been the criticism of Kazakhstan judiciary from the public, legal community, human rights defenders, and international bodies. These are the challenges that explain the low level of public trust in a national court system. Bearing in mind that the requirement of competence, independence, and impartiality of a court is an absolute right that is not subject to any exception, established by the International Covenant on Civil and Political Rights in the Article 14, Right to Fair Trial, we started addressing these issues from the legal and practical perspectives. When devising specific measures, we adopted the approach of incremental change, which says that a change in the qualities of a system occurs when the accumulation of quantitative changes reaches a certain limit. Following this principle, we ask the question with regards to each of these problems: what initial incremental changes need to take place in order to steer the motion of systemic change in the right direction? Independence of judges and courts. We address this important issue from 4 aspects: internal independence of individual judges, development of judicial self-governance, system of checks and balances, and financial independence of courts. For these objectives, a number of measures were taken. We limited the role of court chairpersons in influencing judicial careers and disciplinary sanctions. Their tenure was limited to 2 terms. Reforms in electronic case assignment prevent them from influencing case distribution. Now, their functions primarily focus on managerial issues. As a result of these changes, the position became unattractive for judges, and therefore now every 4th district court currently doesn't have a chairperson. The judicial jury, a disciplinary body, was transferred from the Supreme Court to the High Judicial Council. The Council is an autonomous government agency which doesn't make up a judicial system, but is responsible for the selection, promotion, and expulsion of judges from the bench. The Council has acting and retired judges as members, along with representatives of government agencies, academia, and legal community. Supreme Court transferred all issues regarding judicial staffing to the High Judicial Council, thus separating these functions from the delivery of justice. Through legislative amendments, Supreme Court established an extended plenary session. It is a convention of delegates of all courts in the country whose task is to elect the members of governing bodies that decide on judicial careers. They are High Judicial Council, Judicial Jury, Evaluation Commission, and Ethics Commission. This allows every judge in the country to be engaged in the decision-making process on the important issues of the judicial system. To ensure more financial independence, we managed to move away from the old practice where the courts were dependent on the executive for its resources to the system of a fixed budget. This gives relative financial stability and allows for more effective planning of judicial resources. Public perception survey of 2020 demonstrated that professional quality of judges is the single most important predictor of public confidence in courts. To remedy the situation with judges that developed over the years, we worked in 3 main directions. First, we raised the bar for the entry into the profession to ensure quality of candidates. The success rate dropped to 6% from previous 25%. We introduced new performance evaluation methodology to detect professional incompetence. We studied advanced judicial performance evaluation methodologies internationally, and based on them devised our own instrument implemented by the newly established Justice Quality Commission. It has 16 criteria reflecting all aspects of judicial performance. It uses data from the electronic case management to be able to compare judges across various groups. It allows detecting so-called free riders from diligent professional judges. To ensure objectivity and impartiality, we use coding, random selection, and random scoring of cases. During the first round, 10% of judges did not pass the evaluation based on findings of serious grounds of incompetence. In such cases, the High Judicial Council considers these judges for possible demotion or dismissal. It has to be noted that performance evaluation is the instrument for professional development combined with judicial education. After initial rounds, the evaluation has proven to enhance accountability of judges, evidenced by the increased number of successful results. Third, we made the judicial career attractive for the strongest lawyers in the country. This was done by increasing their remuneration and improving conditions of service, as well as by introducing flexible prerequisites that reward outstanding legal achievements more than mere length of judicial career. According to the same survey, 24% of public believes that corruption in the judiciary is common, while only 15% are confident that it never happens. To change this perception, the reform focused on classical approaches of enhancing institutional safeguards, creating financial incentives, and strengthening accountability. Thus, modern technologies allow for increased transparency through electronic case management, audio and video recording of trials. The remuneration of judges has been significantly increased to minimize any justification for resisting corruption. This, in effect, led to the highest single increase in the budget of the judiciary for the last 5 years. The policy of a closed corporate culture, which prevented accountability of judges, has given the way to open and transparent investigation. As a result, more judges were held accountable for corruption charges in the last 3 years than previously. Kazakhstan, along with other former Soviet Union countries, have had extremely low rates of acquittal in criminal cases, which was associated with an accusatorial bias. Adoption of the Criminal Procedure Code in 2014, which introduced some pre-trial filtering of cases, has not noticeably changed the infinitesimal rate of acquittal. One thing is clear: criminal justice process is the function of roles of police, prosecutors, and judges. Without meaningful change in these institutions, it is difficult to achieve any breakthrough in the public perception of bias and lack of impartiality with regards to criminal courts. With these limitations in mind, the reform focused on 2 objectives. First, empowering judges to stand against law enforcement pressures. And second, expanding the legal framework for more jury trials. As a result, we see the decline in the number of convicted persons by 2.2 times. Most of it occurs in serious criminal cases as opposed to light misdemeanors. It is important because such judicial practice has the potential of nudging the law enforcement agencies towards improving the quality of investigation in serious cases. Another marker for change is how often the courts took the side of defense lawyers in challenging the actions of police and prosecutors during pretrial investigation. Now more than a third of complaints are satisfied by courts, compared to 25% previously. In 2018, the Supreme Court supported the legislation that expanded the categories of crimes eligible for jury trials from 13 to 32. From 2023, all crimes with the highest criminal penalties shall be tried by the jury. Fairness of proceedings was also criticized in civil cases when businesses had disputes with government agencies. Due to long-standing history of direct or indirect influence of the executive agencies over courts, it was difficult for private companies to win litigation against the state. Probability of winning was around 14%. To aid the investors in 2015, Kazakhstan established a special chamber for investment disputes. Over the years, judicial practice of the special chamber has transformed from the civil law tradition to administrative justice. This is illustrated by the outcome on foreign investors' disputes with the state ruled by the special chamber. One significant development is that Kazakhstan has finally adopted a new code to establish proper administrative justice procedure to regulate disputes with the state. It took the country 15 years. On the practical side, this entails 21 new courts and regional chambers, including Supreme Court Chamber on Administrative Justice. On the legal policy side, this signifies new rules of the game that favor citizens and businesses to protect their rights against the state agencies and hold them accountable for maladministration. In 2018, judicial system experienced the highest level of caseload in the history, more than 70% of which were non-litigious claims. The courts turned into legal conveyor belts to stamp court sanctions. This meant less attention to real legal disputes. Such caseload, combined with the pressure to comply with the time limits on the length of proceedings, was one of the reasons for the diminished quality of justice. By taking comprehensive legislative measures, the Supreme Court was able to divert non-litigious claims to the administrative realm. As a result, the courts receive 3 times fewer cases now compared to the critical year of 2018. The judicial decisions were heavily criticized for their format. There were massive unstructured texts overloaded with legal jargons and irrelevant information. To nudge the judges into writing and thinking clearly, we borrowed the format of decisions of international courts and tribunals. Numbered sections and paragraphs helped to structure the text in logical sequence. In addition, the judges were asked to explain their decisions to parties upon reading the ruling. Such a small step of simple language explanations won overwhelming support of court users across the country. For the court spaces, the Supreme Court is adopting and implementing a human-centered design approach. Currently, 2/3 of all court buildings have been renovated to provide customer-friendly front offices. These are comfortable spaces designed to meet the needs of citizens for information and quality court services. So how can we measure the success of reforms over a relatively short span of 3 years? We suggest looking at the independent global indicators and national survey data. In global rankings, Kazakhstan is demonstrating progressive improvement in all major justice-related indices. On the national level, at the request of the Supreme Court, in 2020, UNDP, under the World Bank Justice Project, conducted 2 surveys by an independent survey agency. One was on the general public perception of the judiciary, and second was on satisfaction of court users. As you can see, the perception of the general public is worse than the actual experience of court users. Only 53% of the general public trust courts, while 67% of court users are positively satisfied with their experience. Similarly, judges are perceived more negatively than their performance in actual cases. This phenomenon can be observed in other countries as well. It only speaks of the difficulty of changing public attitudes and values. Accumulation of current experience in courts may take time before it affects general public opinion, which is normally formed by tradition and history of trust to general public institutions, as well as actual experiences and incoming information flow. By no means do the reforms stop at this point. The main directions will continue building on the current results. I would like to briefly mention a few initiatives which are currently work in progress. The first is the three-tiered criminal justice system. The three-tier system is aimed at building a strong mechanism of checks and balances in criminal procedure. Thus, based on clear division of responsibilities, police will only investigate and solve crimes. Prosecutors will filter cases to decide which ones deserve a full-scale criminal prosecution on behalf of the state. And courts will be free from procedural influence to ensure true equality of arms in the adversarial hearing. For this purpose, two strategic measures are proposed. First, new rules of evidence. Only information presented and deemed admissible by the court can be used and shall be considered as evidence in criminal prosecution. Second, new rules of procedure whereby the court receives only the indictment from the prosecutor and a statement of defense from the lawyer. The complete criminal investigation files collected by the police shall be presented only in court. This is to ensure that a judge is free from the influence of any information which presumes the guilt of a person. Court technology is moving to the next level. To further transparency of court decisions, consumers will be provided with a smart search engine to effectively find the relevant case law. A new service will allow calculating the probability of the case outcome to make informed decisions on litigation strategies. For the judges, the Supreme Court is planning to launch an electronic assistant which would enable drafting the decisions in simple, straightforward cases. It is estimated that this innovation will cut the bureaucratic paper load for up to 30%. Use of online courtrooms during the pandemic prompted us to think about extraterritorial jurisdiction. It means that when claimants apply to court, their cases can be assigned not only among the judges of the local court where they apply, but among all the judges in the country for a trial to be held online. This will have two possible benefits. First, impartiality of judges and freedom from any local influence. And second, it will balance the workload of judges across regions. To strengthen the reform initiatives, I would like to use this opportunity and propose several recommendations. First, engage more local judges to develop judicial leadership that will drive change from bottom up. Second, focus on high-quality judicial education to bring a new breed of judges, highly competent and independent in their mind and spirit. And third, involve independent, multidisciplinary teams of experts to evaluate the impact of these reforms on the judicial system and beyond in order to have strong evidential basis for future reforms. This presentation in no way makes full justice to all the hard work, trials and tribulations that went into these reforms by a team of brilliant lawyers. I will not have enough time in the day to name all of them. But there is one person who brought us all together. And so in conclusion, I would like to extend my deepest personal gratitude to the Chairman of the Supreme Court for his leadership, openness, and commitment to meaningful justice reform in our country. Thank you for your attention.
Thank you very much, distinguished Nazgul. Thank you for your presentation, distinguished guests. Before moving to questions and answers, I would like to make one important comment. As you know, judicial system differs significantly from administrative bodies. Every judge takes his or her decisions on his or her own without being subordinate to anyone and is not reporting to anyone. Therefore, neither Supreme Court nor myself as the Chief Justice are not entitled to comment on the decisions taken by the judges on specific cases. This is the rule which is active in the whole world. And therefore, we'd like you to take this into account. And one more, we need to have an independent moderator. For this mission, we have invited Rahmetulin Akan Akasovich, Vice Minister of Foreign Affairs. Many of you know him very well. So, therefore, I would like to give the floor to you. Thank you very much, distinguished Mr.
First, I would like to again introduce myself. I am Akan Rahmetulin, Deputy Foreign Minister of Deputy Foreign Minister of Kazakhstan. And to be honest, I am today really astonished with the quality and the content of today's presentation. And as rightly mentioned, Mr. Chairman, that today's event is really unique because it's for the first time ever the Supreme Court is organizing this kind of briefing for the diplomatic corps. And also I would like to pay my respect and I take off my hat to Ms. Yergalieva for her outstanding presentation. And today I would like to turn to the session of question and answers. And there are 3 channels to ask your questions. The first one is directly from this audience. You'll be provided with the mics. And for those who are online, there are 2 options. The first one, you can type your question in the chat window, and the second one, you can use the raising hand button. So please, the floor is open for the questions, and we will proceed immediately with answers. Please. Yeah, before you ask your question, please, I kindly ask you to introduce yourself, because I'm not aware of many of you. Thank you.
Thank you very much. I am Dr. Muntasir Abu Zaid, the Ambassador of the State of Palestine to the Republic of Kazakhstan. First of all, I would like to appreciate the nice lady who gave us excellent presentation and gave us clear picture. So my question, and the second thing, I would like to welcome our Deputy Minister of Foreign Affairs. First time we see him, he is new. I think that you were ambassador in Pakistan. My colleague there, the ambassador, informed me. Thank you. So I have my small question for the judge, судья. Какая основание?
On which basis judges make their judgments? As far as I know, in any country, the judge has the source in order to make the decision. This basis, this is a legislation of the Republic of Kazakhstan. Is there any other basis that the judge can use if, in case of any conflicts between people, as the decision taken by the judge should be fair? So what basis the judge has in order to make this final decision besides the legislation of the Republic of Kazakhstan? Thank you very much for your question. We have the division of powers into executive branches, judicial, and administrative ones. So the judicial power doesn't write or adopt laws. This is done by 2 other branches of power. As for the judicial power, judiciary applies and ensures the fulfillment and implementation of the laws adopted by the executive branch of power. Therefore, in our constitution, there is a list of sources of law that the judges use as the governance. Of course, these are legislative acts, international treaties ratified by the parliaments. These are normative decrees of the Constitutional Council and decrees of the Supreme Court. So, and plus there are bylaws adopted by the competent bodies for the purpose of implementation of the law. So any state body, if the state body adopts any bylaw, it means that the law, that the parliament entrusted these rights on the specific law, and these bylaws are to be registered with the Ministry of Justice of the Republic of Kazakhstan. So, besides the legislation, there are no other sources of law for courts. Of course, the laws cannot regulate all the nuances and circumstances in our life. Therefore, besides the legislation, they also use their internal beliefs, professionalism, honesty, integrity, and so on. Thank you.
Thank you very much. Right Honorable President of the Supreme Court. First of all, I should say that I feel extremely encouraged to see this convincing amount of work which has gone into the reform of the judicial system. And I think that's what we are all trying to achieve together, and if we can support this development, we are very happy to also contribute. But I do have a very concrete question. On my desk at my office, I have a case where we have a decision of the Supreme Court which is not complied with by the government of Kazakhstan. And the judges can only function, or the courts can only function if decisions which are final are complied with. So I'm a little bit wondering if there is a discussion going on between the government as the supreme executive organ and the Supreme Court about cases like that. I'm not sure if I have a unique one, but it seems to happen. And number two would be a question we have today, Mr. Campbell Holt of the Astana International Finance Center. President Tokayev has mentioned when he had his last address that the AIFC courts will play an increasing role with investors' disputes. How inside Kazakhstan? So this is tendentially conflicting with the normal judicial system. So how do you see the future division of labor between both systems? Thank you very much.
Большое спасибо.
Thank you very much. In fact, your question really supports me in my dispute with opponents. You mentioned that the decision of the Supreme Court is not enforced by the government. I will be open with you. It's not a single fact. Unfortunately, there are many examples like this. I know the history of this question, as in today's presentation, Nazgul Ergaliyeva mentioned 15 years during which we discussed the necessity on adoption, the law, the code on administrative justice. In fact, this is a dispute with state bodies, and not only with them, but also with those structures that take certain decisions, that have certain powers with regard to population, business, even the Bar Association, with regard to those persons whose questions are being resolved. Therefore, I think that thanks to International Council, we are going to have a meeting of International Council today, distinguished members of International Council, our colleagues, you can see them on the screen, in particular, Mr. Jörg Pudelka, judge from Germany, who helped us a lot. 3 years ago, during one of the meetings of our council, he criticized a lot, and by the way, he spoiled my mood, and I had many hopes entrusted with that code. And then I invited him for a cup of coffee. We had a discussion, and he mentioned all these deficiencies, even those that you're mentioning now. So therefore, we are not ashamed to acknowledge our mistakes, our deficiencies, drawbacks, or painful spots, as we cannot move ahead without that. Mr. Pudelka didn't have time as he was quite overloaded, and I really asked him, probably coffee also played certain role here, so he promised to help us. And last year our parliament adopted, and he only not helped us to develop this draft law, but also he accompanied this draft law in the parliament. All lawyers, parliament deputies know him. So these problems should disappear from the 1st of July. And I would like you to focus on the following moments. In the presentation, it has been said that we are really interested in joining the judiciary system by the strongest lawyers from the corporate sector, especially from Big Four, and many other companies. So therefore, we are inviting them now, so that from the very first days, this code that we rely a lot on, as we're talking about the disputes with the state. What this code is about, an individual or business representative, especially investor, it is enough for them to express their discontent, and they're not obliged to provide arguments for that. It's just enough to state this claim. The judge will not comment that the form was wrong or the text is not written properly. What is important is that they should understand which decision or lack of action that this person is not satisfied with. And after that, the judge is on the side of this person. And the state should prove that its decision or inaction is justified and is the only right one, which is presumption of guilt of state bodies. If this judgment is not enforced tomorrow, then there are specific tools. The judge, well, if today all the decisions are ensured by so-called judicial enforcement officers, then according to this law, the enforcement will be ensured by the judge. The judge will control the enforcement of his or her judgments. After a certain period of time, the judge is entitled to impose penalty personally against certain state officer. And it can be done several times. So you probably understand now why it took us 15 years to discuss this law, as many state bodies understood that this law is not for their benefit. There is a whole team that worked together with Mr. Pudelka, who developed and defended this law. And I'd like to repeat, in general, the judicial system has three main directions. The first one is administrative justice. The second one, civil disputes. Disputes between individuals, companies, where the state is not involved. This legislation is also being reformed now. Just 2 weeks ago, we have informed the Supreme Council on Reforms, and the Council approved our approach, and now we are submitting this bill to the Parliament, and we hope that by the end of the year, civil disputes will also be settled based on the international standards. And there is the third direction, the most painful one, criminal legislation. And here, by the way, we have these polemics for about 5 years. Nazgul Irgalieva has explained its meaning. I would like to repeat. Clear distinction of zone of responsibility between police, investigation bodies, prosecutor's office, and court. The police detects, investigates the crime, resolves the crime, collects evidences, and then these documents are submitted to the prosecutor's office. We are not inventing any bicycle here. We took this experience from Germany, using the experience of Germany. And Georgia also used this experience to adopt the system, and Baltic countries. I personally visited those countries in order to personally understand and be convinced that they are right. And when the person is convinced, it's easier for this person to have disputes with opponents. So in terms of police side, that police should only collect evidences, but police should not give evaluation to the case based on the evidences it collects. Now, what about prosecutor's office? It evaluates the materials collected by the police, and prosecutor's office is not interested in improving the police indicators. Prosecutor's office has different tasks, so therefore they evaluate. They act as a filter between the police and the court. As for the court, again, we're not inventing anything new here. There should be a real adversarial system in the investigation. We're still arguing on this position. This is the position of the Supreme Court. I do believe that we will be supported as law enforcement bodies have different opinion. I think that the judge should not read the case materials before the trial. He should come to the trial without knowing anything. Only he or she should read the Indictment Act and the Defense Act. Because when the judge reads the material of the whole criminal cases that were prepared by the prosecution side, of course, certain paradigm is established in his or her mind. It is easier for the judge to believe the prosecution side. Therefore, this prosecutional bias is formed. But this is the position of the Supreme Court. I would like to repeat that. The final decision has not yet been taken. But on our side, we are going to talk about that, and we are going to defend that. I apologize for delaying my answer and for going beyond your question. Thank you.
Sure, intrigued by Ms. Jägeliva. I would like the following question. How does how does the jurisdiction and the judges and how do the lawyers backstop legislation? So if I'm a judge and I see that the legislation is not good or can be improved, how much can the judiciary, how can a judge or a lawyer, the lawyer association, how can they backstop and give something to you, the Supreme Court, or to give to the system to improve legislation? Thank you.
Спасибо. Есть два пути.
Thank you. There are two ways. Well, concrete situation. The judge sees that the legislation is not perfect, or the specific norm is against constitutional principles. In this case, the judge is entitled to suspend the case and to approach the Constitutional Council with a request to explain the constitutional norms where they're talking about the human rights. And Constitutional Council is entitled to acknowledge any legislation norm as unconstitutional one. That's if the judge had any doubts in the constitutionality of the certain norm. But if he or she doesn't like the law, well, but we cannot be identical. We have different standpoints. Of course, the judge is obliged to to be governed by the law, if, at his or her opinion, it is not against the Constitution. Well, another thing is that the judge is entitled to submit this private decision and to send his or her doubts to the relevant competent body that in the government initiates this type of legislative novelties. Thank you.
before we proceed further with questions, I would like to remind you that we have a time limit in this Q&A session. And after your question, I would suggest if we have comment from online from AIFC court registrator, and then we will complete the Q&A session. Thank you for your understanding.
Thank you very much for giving me the floor. Thank you, Head of the Supreme Court and Deputy Minister, for organizing this briefing. It has been, as it has been already said, very informative, and we really profit from this sort of briefings. And we are thankful for this occasion and also the briefing that you have organized. The presentation also was extremely interesting and informative. And starting from the presentation, I can really say that Kazakhstan can duly claim credit in embarking on the reform and modernization process of judicial system. As we all know, if you don't take the small steps, you cannot take also the giant steps. So it is small steps builds up into that giant step that we would like to take eventually and come to the objective that we are heading for. My question regards a statement which was made by the head of the Supreme Court in the past. In that statement, you expressed concern on 3 issues. The first one was lack of fair trials, and the second one, lack of independent judges, and the third one, poor judicial oversight. You are referring to the judicial process that is going on in Kazakhstan. So my question is, in which of these areas you are finding it really difficult to come to or to adopt some measures in order to counteract the difficulties that you are encountering on the judicial reform process? And which of these 3 issues, according to you, have given you some kind of satisfaction for having excelled, to put it beautifully, in the process of the judicial reform and modernization? Thank you very much.
Thank you. If we go back to 3 years ago, I would leave my office with a good spirit every day whenever we acquitted someone. In 2018, I think that that year was special because the Supreme Court had 75 acquittals. And that never happened before in our history. Of course, for professional judges, that was some kind of a shock because the judicial practices started to change. And this is what has been mentioned in the presentation today. Because if we look at the total number, the acquittals increased by 2.2, but when it comes to very serious crimes, in comparison with the last 3 years, the increase was 8 times. And that is why the main source of joy for me was the independence of our judges. That happened when our judges realized that the courts are not the continuation of law enforcement agencies, that the judges are not state officials, that the judges are above everything and they need to have this helicopter view, and independence here mattered a lot. After independence comes justice or fairness, and fairness determines the quality of our judicial personnel. We realized that there was a high turnover in staff, and mainly it was related to the fact that the work of a judge was like a conveyor belt that Nazgul was talking about, because here in the capital of Kazakhstan, one judge, and I'm not exaggerating, I hope I'm not mistaken right now, per day one judge would make 51 court decisions in one day. And mostly these were sanctions. Mostly these were specific cases, court proceedings, and so on and so forth. And when we started to dig into details, we realized that there were a lot of functions imposed on judges, which were not supposed to be imposed on them. These functions were supposed to be fulfilled by the administrative bodies, especially when there was no dispute. And the state bodies need to undertake responsibilities and make relevant decisions. The courts are needed whenever there is a certain dispute between a person and the government, between certain individuals. That is why I think that in 2019 we managed to convince Parliament. And there was the address of the president of the country to people. I think we've shared the slides with all of you, and these slides have more content comparing to the presentation that was provided to you today. And these slides have all the content, all the information as a result of those orders or decrees issued by the president of our country. And of course, there are a lot of issues to resolve. We really hope that with the current status of our reforms, as part of the Supreme Council for Reforms, we will be able to take another big step forward, because we have a lot of plans, we have a specific vision of what needs to be done, especially in the field of criminal proceedings. That is why I really hope that in the future, I will be satisfied with all three issues, not one of the three issues. And you know, life is changing. Even developed countries tend to carry out a number of reforms. I personally was in Great Britain, and I talked to the British judges, and I was astonished by their issues. I would never think that they would have any problems, and as it turned out, they had a number of issues. That is why I think that what matters is that we have our vision. We know how to overcome our issues, how to overcome our challenges. And in addition to that, we have a professional team that is capable to resolve these issues. And we have the will of the head of state that reflects the progress that we try to reach in terms of our compliance with the global standards.
Mr. Christopher Campbell Holt, the representative of Astana International Financial Center Court. The floor is yours, sir.
Можно будет я небольшую справку?
May I first of all, may I provide a reference? Just FYI, we have a very close cooperation with the AIFC Court, and the Supreme Court of Kazakhstan is really interested in making sure that the businesses transfer their cases to the International Arbitrage Center and to the AIFC Court. We are quite interested in that because, first of all, our judges have an opportunity to learn from foreign peers, and our businesses, our investors have the opportunity to take part in certain litigations without leaving the territory of Kazakhstan, and they can be pretty sure that professionals will be in charge of their cases. Mr. Campbell-Holt, the floor is yours.
Thank you very much indeed for this opportunity to say a few brief words in response, I think, to what has already been said, but on a couple of other items as well. Firstly, if I may, I would like to congratulate the person who made the presentation. That, by any international standard, is a shining example of how, under strong, coordinated, focused and expert leadership, through the Supreme Court, if I may say so, by Chairman Asanov and his team and the government of Kazakhstan, quite remarkable results can be achieved very, very quickly. My own country, England and Wales, the legal system there, would be quite envious if they were able to achieve so much progress in such a short period of time. So if I may, on behalf of our Council and the AFC Court, congratulate everyone involved for what has been achieved. And although there's still talk of existing continued problems, I would focus very strongly on the need, if I may say so, for Kazakhstan to positively promote the achievements that have been put in place already. Now, very quickly in response to one or two of the questions, there was one question in particular with regards to potential investors bringing disputes to the AFC Court. I might add, if I may, that investors can do so if they consent in writing in any written agreement, an investment agreement, contract or otherwise. They may also bring that dispute, if they wish to do so, to our International Arbitration Centre. Both the AFC Court and our Arbitration Centre, absolutely world-class dispute resolution, applying the very high standards of the rule of law. The independence of the court and the arbitration centre is critical to gaining the trust and confidence of investors. I'm saying the obvious, that's known for everyone, but how do we actually achieve it? Which will lead me to explaining the second part of the question on enforcement. We have guarantees of independence in the law in Kazakhstan, which provides for the establishment of both the court and our arbitration centre at the Astana International Financial Centre, the AFC. We have world-class, based on the common law, procedural rules at the court and international standard procedural rules at the arbitration centre. These also guarantee, through a day-to-day process basis, if you like, the independence of the proceedings for dispute resolution. But above all, our independence is absolutely guaranteed on a day-to-day basis by our judges, led by Lord Mance, the former Deputy Chief President of the United Kingdom Supreme Court, and 8 truly first-class and most internationally respected judges from the English and Welsh judicial system. The Arbitration Centre is led by Barbara Doman QC with more than 40 years experience at the highest international level, one of the most respected arbitrators, mediators and commercial litigators in the world. So we could not be more fortunate in Kazakhstan, for the first time in Central Asia, to have a truly world-class common law court and arbitration centre. Now, with regards to the question on enforcement, the AFC Court has a very specific step-by-step procedure which guarantees enforcement. I say guarantee, life is never that simple in practice. However, so far, as we are still in the second quarter of our only 4th year of operations at the AFC Court and Arbitration Centre at the AFC, we have successfully resolved 447 cases. I believe that is unprecedented for our type of business anywhere in the world, still at this very early stage of our development. I can tell you that all of those cases, without fail, where necessary, have been forced to 100% satisfaction within the entire territory of Kazakhstan. Not just in the Sultan, within the jurisdiction of the AFC, but throughout the entire territory, geographical territory of Kazakhstan. We've done that through specially negotiated, signed, and then implemented in practice at a day-to-day level, step-by-step procedures on enforcement, where the AFC Court engages directly by application of parties to disputes at the AFC Court for enforcement purposes with the enforcement agents, whether that's with the Private Bailiffs Association for enforcement against private assets located anywhere in the territory of Kazakhstan, and secondly, against state assets through the Ministry of Justice. The Minister of Justice himself has signed this step-by-step procedure, as has the chairman of the Private Bailiffs Association. So far, this enforcement has been, as I said, 100% satisfied in practice. We currently have ongoing cases at the court and arbitration centre involving the state of Kazakhstan, and we expect in the short-term future to be able to positively report to you all and the world successful enforcement statistics with regards to actions against the state of Kazakhstan, if, of course, that is necessary in practice. Now, there are movements at the moment in the laws of Kazakhstan. This seems to be ongoing. We know at the AFC Court and Arbitration Centre at the AFC that we are being constantly engaged and consulted on the potential reforms to legislation within Kazakhstan. I understand that it is expected in the short-term future that there will be considerable amendment to investment legislation in Kazakhstan, which will enable international investors or any parties, if they decide themselves with their parties in disputes, to use the AFC Court or Arbitration Arbitration Center for Investment Disputes. Now, we're enormously grateful to Chairman Asanov. We cannot explain that enough for our 4 years plus now a partnership and cooperation from our court and arbitration center at the AFC. That cooperation has lended itself to sharing experience between our judges and arbitrators and the judges of the Kazakhstan courts with the Justice Academy of the Supreme Court of Kazakhstan to this transfer of cases scheme, which Chairman Asanov just mentioned. That cooperation is and will continue to be.
Excuse me, sorry to interrupt you, Mr. Campbell. Unfortunately, we're running short of time, and if I may ask you to wind up your, just limit your presentation or comments in maybe in half minute.
Thank you very much. I apologize for talking too much. I was just ending what I was saying, and that is that cooperation will be critically important for the successful interrelationship, if you like, of an independent AFC Court and Arbitration Center and the independent courts of Kazakhstan towards enforcement and to avoid potential conflicts going forwards. Our court and arbitration center will be respectful of actions being taken by the Supreme Court and the local courts, and that will in practice lead to successful operation for both investors and for the local system.
Thank you very much. Thank you. And I would like to give the floor to Mr. Jörg Pudelka. Mr. Pudelka, the floor is yours.
Yeah, thank you very much. Спасибо большое. Я очень коротко.
I would like to be brief. I wanted to briefly mention the huge reform which is being implemented in Kazakhstan now due to the implementation of the new administrative procedural proceedings code. Since we're short of time, I would like to highlight one moment here. And distinguished Mr. Ambassador also mentioned that with APPC, effective measures for protection will be given to claimants. This is related to 4 types of claims in administrative process. And there are claims that also exist in Germany and other countries that have administrative justice, and it means that the court cancels administrative acts. No enforcement officer is needed. The court decision has final effects. I think it's one of the moments that will improve the enforcement of judicial acts. This is a large-scale reform, a true reform. It's not just an improvement of the code that existed a long time before, but this is the new legal area, and many state bodies will be obliged to defend that their decisions are correct. They will have to listen to other parties before taking these acts. There will be special administrative courts established that will be specialized on settling public administrative disputes following inquisitional principle, which means the active role of the judge. And this will help especially citizens who do not understand the law. As it has been mentioned, the court will be on their side. In general, this comprehensive reform will further improve the rank of Kazakhstan in international rankings, and we can also expect improvements of investment climate. And at the end, I would like to highlight, yes, the law is good, the code is good. And compared to other countries where such administrative justice was introduced, I would like to highlight and congratulate Kazakhstan with comprehensive actions aimed at improvement of qualification of judges and state officials who are taking these laws. And the huge work is done in the Justice Academy. I think it is important, as if the law is well written and if it doesn't work in practice, There is no need of that. And I think Kazakhstan has all the chances for the success. Thank you very much for your attention.
Curtis Masters from the United States. He's also from the foreign component of the International Court, Council of the Supreme Court.
Thank you very much. I've been practicing law in Kazakhstan since the late 1990s, and I can honestly say that the level of reforms in the judicial system in Kazakhstan has truly been remarkable since then, particularly over the last 4 years or so. I thought the video at the beginning of today's briefing was very interesting. I had not seen it before, but I think it was very accurate, and I have no disagreements with it at all. I thought it very well presented the situation in Kazakhstan, as did the speech by Ms. Yergalieva. So I don't want to repeat anything they said, but I'd just like to emphasize a couple of points that they mentioned, just so people really are aware of some of these reforms. One is the digitalization of the courts in Kazakhstan. Virtually everything is filed with the courts electronically these days. And also almost all hearings in Kazakhstani courts are held online. That's really pretty remarkable, but what's even more remarkable is that this was done prior to the pandemic, and as a result, the pandemic had almost no effect on the operations of the courts in Kazakhstan. And that's probably one of the few court systems in the world that can say there was the COVID pandemic had almost no effect on their operations. So I think that the courts in Kazakhstan, particularly the Supreme Court, deserve a lot of credit for the digitalization and the online hearings which they implemented prior to the pandemic. A few of the other things that were mentioned, I'll just note, that's the Administrative Procedure Code, which the Supreme Court was a major stakeholder in and was, took a big role in implementing, and it created branches in the courts in Kazakhstan which hear disputes between administrative authorities and private parties. And that's the first time anything like that's been done. It's really quite an innovation. And several years prior to that, the investment panels at the Supreme Court and at the Astana City Court were set up to hear investment disputes. Also, first of its kind, I think, anywhere in the world. The quality of judicial decisions has improved dramatically over the past several years. Judges are constantly going through training. I've had one or two judges tell me that they have trouble getting their work done because they're always going to training sessions, but that's a good thing. Two things that clients and potential clients often ask me about are corruption and independence. And as far as corruption goes, I've spoken to Chairman Asanov about this, and I know he has a zero tolerance policy towards it. And there have been major improvements in this area in the past several years, and the level of corruption has dropped drastically. Has it been eradicated? No, it has not been eradicated. But in my view, it's really no longer a serious problem. As far as independence of the courts go, independence from the government, that's something that really pretty much needs to be dealt with at the political level by the government. To a large extent, it's outside the control of the courts, but I know that both the first president as well as President Tokayev have stated that the independence of the courts are a priority for their administrations. And I know that slow and steady progress is being made in that regard. So I think positive steps are being taken to ensure and improve the independence of the Kazakhstani courts. So in summary, I guess I would say the level of reforms in Kazakhstan's courts have been, in my view, rather remarkable. And in my view, having worked in this area for a very long time, I consider the court system in Kazakhstan to be one of the best, if not the best, in the former Soviet Union. So I congratulate everybody involved in that.
Thank you very much. And I think we have one more request from for the floor. Yes, please.
Good afternoon. Assalamu alaikum. I would like to congratulate and thank for organizing this very important briefing, Well, actually, we were looking for this for many time and request also meetings. But it's a great honor and pleasure to be here. And also, I would like to thank and congratulate Ms. Nazgul for excellent presentation. Well, I echo my voice again with the colleagues for to congratulate for all these achievements. But as you know that in development, recently all believes that in development, if there is no prosperity, it makes no sense. And in excellent judiciary system, if it's not the second phase, which is the implementation of the decision, is very important. And I am very glad that hear from you that you say that this is not the only one case, which is with the German embassy. So here I would like to announce from our government side, Republic of Islamic of Afghanistan, that we will be very glad to cooperate with you for further development in the issues we have among ourselves. And I would also like to mention the last point. Judiciary system is very important. The next step is the implementation, very important. And the third step, which may not been mentioned here before, is the building the trust again between two parties. Whenever the investor is going through these cases and takes them 3-4 years, and their $1 million is stuck somewhere, then I think there should be another step, whatever party from the government, to build back the trust. And the trust is the most important today in the world in business and investment. I congratulate you once again. Thank you very much.
Thank you very much. And
Если позволите, я немного...
If I may, as you have raised an important topic, in 2018 I visited Singapore, one of the district courts. So that was the district level court. What I was surprised with, there were 86 judges working there. I was said that on the first floor there were 11 judges that differ from all other judges that work on the other floors, as they deal with different types of cases. I've asked, what are these cases? And they told me that all claims are received by these 11 judges. Their task is to reconcile parties, and they succeed with that to 95%. 95% of parties came with claims, with case to the court. They settle it amicably. They keep these relations. Someone told that the court that resolves claims amicably is deemed almighty. So 95%, no disputes. And the remaining 75% of judges take only this 5% of cases for proceedings. So why I'm mentioning this? When we started to implement our reforms, well, what we saw there, we saw three most important things. This, and then the second one, night courts, especially on the road accidents. Courts work when it is convenient for citizens, and not when it is convenient for the courts. And what night court means, it's the work during 6 hours up to 10 p.m. So we launched this pilot using the experience of Singapore. So the law is adopted now, and now this project is fully operational and successful. The third, family courts. In our disputes, 30% of disputes are about family relations. Well, it is not yet implemented, but we have a dream that next year we will implement that. Therefore, reconciliation, mediation. You know, what I notice here is that in the developed countries, the buildings where mediators are sitting are larger and more modern compared to the buildings occupied by judges. So I think that the demand for judges in future should be reduced. People should strive for compromise and for amicable dispute settlements.
To an end, and a small announcement for those who are online and who are not able to ask a question, you are welcome to do that. You can send your questions to the organizers in the Supreme Court, and all questions will be responded in due course. Thank you very much. And a short also announcement, immediately after this briefing, you are invited to a coffee break where we can continue our conversation. And just for closing remarks, I'm passing the floor back to Chairperson.
Уважаемые гости, в
Dear guests, in conclusion, I would like to say that judicial reforms take place in each and every country. This is a continuous process, and Kazakhstan is not an exception. Of course, we do not say that our courts started to implement everything ideally. Right now, we focus on the implementation of justice as part of our judicial reforms. We have our legal foundation, which is compliant with the global vision of the modern justice. Of course, there are separate laws and regulations which need to be changed or which need to be calibrated. And there is a need in having this paradigm shift of thinking of separate judges. Hopefully, you came to realize that our judicial reforms are on their most active phase. We have the momentum, we have positive trends, we see promising prospects for cooperation with the International Arbitration Center and the AIFC Court, and Mr. Campbell-Holt mentioned this today. Our judges learn from foreign peers and get invaluable experience. Business investors have an opportunity to resolve their disputes right here, working with the best judges of the Great Britain. And this is a win-win situation. Dear diplomats, we are ready to share the most relevant news so that you could always have real and objective information at your disposal about Kazakhstani courts. Under the leadership of the head of state, the Supreme Commission for Reforms is successfully functioning. The most important thing is that we have a vision in the future action plan on the development of the judiciary. We have a strong team of professionals and experts, and we are ready to take bold steps in order to ensure bold changes. There is one goal. People, businesses, investors, and partners need to have a trust in our courts and judges. You know, I just had one thought. It just occurred to me, and if that's okay, I would like to share it with you. It seems to me that these kinds of meetings are extremely useful for all of us. In some way, they're more useful for us because during the preparation for this briefing, we pay attention to everything that we've been doing from the perspective of the global standards of justice. We critically assess the results that we have nowadays. That is why, if you don't mind, well, of course, this is the question that is subject for further discussion with the Ministry of Foreign Affairs. But if that is okay with you, maybe we would start some survey among diplomats. We are ready to make sure that such meetings under the International Council are more regular. Maybe we would have another meeting in the beginning of July or June, and hopefully we will inform you about the timeline of such meetings. I would like to say that for now the briefing is over. It's not our last meeting. After a 15-minute break, the members of the International Council will have to get together for another session. Thank you for your attention.